And Myrna Perez is with us. She is the senior counsel to the Brennan Center, brennancenter.org, the website. Senior counsel, head lawyer. Myrna, welcome to the program.
Thank you so much for having me.
And thank you for joining us. I'm curious your thoughts on this argument that's going before the Supreme Court that could conceivably blow up the Voting Rights Act, if I have this correct. Mm-hmm. Give us the details.
Sure. For generations, the Voting Rights Act has been instrumental in protecting the fundamental right to vote. It is one of our landmark civil rights laws. And on February 27th, Shelby County, Alabama, is challenging a very important and effective provision of the Voting Rights Act called Section 5, or sometimes it's called the preclearance provision. What that part of the Voting Rights Act does is it requires certain places that have a documented history of voting discrimination to submit any change they want to do to election procedures to either the Department of Justice or a federal district court before it goes into effect. And it will not go into effect unless it can be established that the change would not make minority voters worse off, or that it did not, it was not enacted to try and make minority voters worse off. This is an incredibly important part of the Voting Rights Act because it stops discrimination before it occurs.
Right, and typically this was enforced against basically the old Confederate states.
Against those states that have had, again, a documented history of racial discrimination.
Right, but historically, was there not a huge overlap between those states?
That's in fact the case.
Yeah. So I'm curious. I want you to give us your thoughts on how this is going to play out and who's behind it and what's going on. But also, it seems to me that Pennsylvania, for example, if Wisconsin, Michigan, you've got states that were not part of the Confederacy, that are not subject to oversight by the Voting Rights Act, because there hasn't been this history of discrimination, that are passing voter ID laws that are nakedly established to diminish the role of minorities in the electoral process. Shouldn't the Voting Rights Act be expanded? Shouldn't the DOJ be saying, hey, wait a minute, we're seeing more of this kind of discrimination?
Well, I think you are touching on incredibly important and interesting points, but there's a bit of conflation that I'd like to clarify.
Please.
If I can. There is a provision of the Voting Rights Act called Section 2, which does apply nationwide. It allows the Department of Justice, it allows private individuals to go after laws that make it difficult for communities of color to elect their candidates of choice.
Is this why Pennsylvania has their voter ID law on hold?
No, that has to do with it being done under state law.
I see, okay.
But the preclearance provision is a particular tool that is targeted and narrow to particular jurisdictions, because it is a very specific reaction to a very specific history. And if and it was based on a lot of analysis and a lot of thought and a lot of research by Congress as to where this tool should be applied. Because it blocks laws before they're allowed to take effect, we want it to be carefully crafted. We want it to be able to apply only in circumstances where it is needed. And the way that Section 5 is devised now, it applies and it protects voters in those areas that are most likely to need that kind of protection.
Right. We're talking with Myrna Perez, the senior counsel at the Brennan Center. Is at brennancenter.org, of course, the website. Is it not pretty much the case that the argument that's being brought before the Supreme Court is, we don't have discrimination anymore, no droids in this car, we don't need this law anymore?
There's certainly a lot of elements that are present in the arguments that sound very much like what you suggested, the idea that discrimination is a thing of the past and that we've made progress and it's no longer timely. And I think that there's no dispute that we as a nation have made enormous progress in terms of racial equality, in terms of ending formal discrimination in our electoral processes. But it's not the case that discrimination doesn't happen. Just over the summer, a 3-judge federal court found that the state of Texas intentionally discriminated, not accidentally, intentionally discriminated against its minority voters when they were drawing district lines. And we have a number of examples in which we still see discriminatory elements, and consequently we need something like Section 5, which will make sure that we stop the discriminatory practices before they're able to infect our electoral process.
Do you think that what are the early indications about how the court might rule on this?
The court has had this issue put before it many times. After the Voting Rights Act was voted bipartisan, almost unanimously to continue in 2006, someone went in and challenged it. Mm-hmm. And in the past, every time the case has been before the Supreme Court, it's been upheld. The record was voluminous. Congress spent a lot of time listening to the evidence, looking at the record, hearing from experts, and the 15th Amendment of the Constitution gives Congress the power to try and end racial discrimination when voting. So I think that the court is going to do the right thing. I think the court is going to do the constitutional thing and is going to give Congress the deference that it is entitled under the 15th Amendment to try and root out racial discrimination in voting.
Wow. I from your lips to God's ears, I hope you are right. I'm hearing, that a lot of people are actually quite spooked by this, given, I'm not even a believer in judicial review. I think Marbury was wrongly decided. So, we want to get into a rant about the court, but that the partisanship, the naked partisanship on this court has gotten so extreme recently. They had a case this week that had to do with the Alien Torts Act where both sides were in agreement. There was no actual claim, and they appointed a third party to bring forward a front of the court brief to basically so that they could create law. It's bizarre what these guys are doing.
I think I certainly hear your concern, but I think the law in this is pretty easy. The 15th Amendment is very clear about what Congress's powers are, and this was not a decision that Congress undertook lightly. There was more than 20 hearings. There was 15,000 pages of documents, unknown number of witnesses, and the decision was made, and it was done so very recently.
Yeah, we have just a couple of seconds left. What would be the constitutional argument to say, instead of we no longer have discrimination? What would be how could they blow it up on a constitutional basis?
How could the opposing side blow it
court,
up on the Constitution?
If the court were to rule against the Voting Rights Act.
The way the ruling would work would be it would saying that it was an overextension of Congress's power. But again, I don't think that that's possible because the 15th Amendment ensures that the right to vote is not denied on account of race and gives Congress the authority to protect this right. Yeah,
that's pretty straightforward stuff. Very, very interesting. Myrna Perez, thanks so much for the enlightenment.
Thank you so much for having me. I hope you'll invite me back.
I would love to. Senior Counsel with the Brennan Center, brennancenter.org. Myrna Perez. Brilliant. Thank you so much. We will be right back.